the record. This is the 6th day of hearing in the case of Sue Novak versus the state of Wisconsin DOC, specifically the Columbia Correctional Institution. This is the, as I said, the 6th day. Today is April 28th, 2023. The administrative law judge in this matter is Alice DeLaO, DELAO. The issues in the hearing is whether or not the respondent violated the Wisconsin Fair Employment Act by discriminating against the complainant in terms and conditions of employment because of sex and terminating the employment of the complainant because of sex. The complainant is appearing in person, although not on screen today because she's at home and she's recovering from her leg injury or surgery, whichever it is. And if she needs to be, she can be on screen, but at this point has decided to relax and stay off screen. So the complaint is appearing, but just without her picture. And the complaint's attorney is also present, who is?
Cross Law Firm, Ben Hitchcock Cross.
Okay, and the respondent is appearing by?
Eric Mullenbach. I'm an attorney with the Department of Corrections. Also with me is paralegal Angela Rinneker, and just observing is DOC attorney Elizabeth Longo.
And then we have our first witness for the day, who is Kelli Brown. Is my understanding correct?
Yes.
All right. All right, Ms. Brown, if you'll raise your right hand. Do you swear the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, to help you God, with understanding that false testimony could be prosecuted for perjury? Do you understand that, and do you agree?
Yes, and I agree.
Thank you. All right, then. I believe you said that there was nothing else we needed to do before we begin the testimony, so you may begin your direct examination, Mr. Mullenbach. Go ahead.
Can you please state and spell your name?
Sure. It's Kelli Brown, Kelli, last name Brown.
And where do you currently work?
I am working with the Department of Administration, Division of Personnel Management, Region 2, which is with DOC.
So can you explain that a little bit? You said you work with DOC, but you are employed by DOA. Can you just explain that?
Sure. All of the HR staff were, I guess, transferred to the Department of Administration back in July of 2018. And we provide, where I work, I provide the specific employment relations services for the Department of Corrections.
Okay. Do you remember when that transfer occurred?
That was July of 2018, I believe.
Okay. And if you said this already, I apologize, but what is your current title?
I'm a human resource program officer. And
what does that entail?
Sorry. That basically means I'm the employment relations chief for the Department of Corrections.
Okay.
So I handle the employment relations issues for the department.
Okay. Judge, when you can, could you pull up Respondent's Exhibit number 4 for me, please?
Sure. Has that been marked yet?
I do not believe it has been.
Okay, then I'm going to mark it before I do this.
Mr. Mullenbach, can you tell me what the title of that exhibit is?
Yeah, it's ED 43.
Oh, okay. Yeah, we won't have an objection.
Okay, great. Thank you. You said 4, correct?
That's correct, Judge.
All right. So I've now marked Response Exhibit 4, pages 68 to 71, Wisconsin DOC Executive Directive number 2, Employee Discipline, and it's been marked as offered, and it has been admitted without objection. So Here we go. All right, then I'm gonna share.
I'm sorry, Judge, I'm looking for exhibit number
Oh.
4.
Yeah, I marked 4, but when
Okay.
I toward the page that tells me when it ends, I can look to the next exhibit, and that's how I end up doing that. Sorry. Thank you.
That's okay.
All right, so we're on response exhibit 4, DOCED 43 work rules. Okay, go ahead.
Yeah, if you could just scroll to this page, please, Judge.
How far do you want to go?
We can start right there. So, Ms. Brown, I'm just going to ask you, based on what you've seen so far, and if you need the judge to scroll down, obviously just let her know, but do you recognize this document?
Yes.
And what do you recognize it to be?
So this is the DOC Executive Directive 43, as it states, and it lists the statewide work rules on it
Okay,
for
and you-
employee conduct.
Sorry to interrupt. You've seen this document before?
Yes.
Is it a true and accurate copy of ED 43? And again, if you need her to scroll down, just let her know.
Yes.
Yes, it's a true and accurate copy?
Yes, it is a true and accurate copy. Sorry.
Okay. Judge, if you could just scroll down a little bit. Actually, if you could just scroll up to the top of the page you're currently on, I'm sorry.
Right there? Or-
Yes, right there. Thank you.
Okay.
Ms. Brown, do you you recognize this, but what is this? What are we looking at here?
So this lists the work rules that the state of Wisconsin has established to govern employee misconduct, kind of like it says. And then towards the bottom of, I think it's actually on the next page, there's also some serious acts of misconduct that are listed, and those are basically kind of enhancers to the work rules. So they can't stand in and of themselves, but they kind of tie in with a work rule buddy is kind of what we call them. So that's what this document shows.
Okay, so if first, Judge, could you scroll down to the serious acts, the next page? Thank you. Okay, so this is the serious acts of misconduct you referred to?
Yes.
And again, I just want to make sure I'm understanding. So an individual could not be charged solely with a serious act of misconduct. It would have to be with a work rule violation. Is that what you testified to? Is that accurate?
Yes, that's accurate.
Okay. So the serious misconduct is just an enhancer, I think you said?
Correct.
So what's the difference? I mean, besides that, is there any other difference between a work rule violation and a serious misconduct allegation?
Yes, there is. So if someone has violated a work rule, which is one of those 1 through 26, I think we have, that was on that previous page, we are able to issue progression. So we have a progression series that's been established throughout all of state agencies. However, if we feel that there's also a serious act of misconduct, so one of these 9 listed, we are able to request a more extensive level up to termination for like a one-time or the first time someone has violated a work rule.
Okay. And Judge, I'm now looking to go to respondents exhibit number 3, please.
All right, was that marked?
I believe it was marked yesterday, yes. But I guess you might want to double check.
Yes, at the end of the day, it was marked and entered. Right. All right, we're on respondents exhibit 3, page 45, and then moving down to the first page
Yes, please.
is 46. Go ahead.
So Ms. Brown, just based on what you see here, do you recognize this document?
Yes, I do.
And what do you recognize it to be?
So this is the Division of Personnel Management Human Resource Handbook Chapter 412, which gives us guidance on the investigation and pre-disciplinary procedure.
And you're familiar with this document?
Yes, I am.
Is this a statewide policy?
Yes, it is.
So does it apply to the Department of Corrections?
Yes, it does.
And do you know when this policy was issued?
I think it was originally issued back in, I want to say like September of 2019.
Judge, if you could scroll down just a little bit on this page, please, to the bottom.
No, that's kind of to the
Right
bottom.
there is, yeah, right there is fine. So the bottom of that first page there, does it indicate the issue date?
Yes, it does.
And what is the issue date?
September 2019.
Okay, so did this replace an already existing policy?
Nope, this was the first time this policy was issued.
Okay. Judge, if you could go to page 51 for me, please, of this document.
All right, we're on page 51 of Respondents Exhibit 3. Go ahead.
And I'm actually going to focus on section 412.070. If so, if you could just scroll down a bit.
All right, that's where you want to be.
So, Ms. Brown, directing your attention to section 412.070, what does this section relate to?
This relates to the ability to temporarily remove an employee from the workplace and continue to pay, and keep them in pay status while an investigation is conducted.
And who makes the, well, according to this policy, who makes the determination to place someone on administrative leave?
The appointing authority.
And when is administrative leave appropriate under this section?
So it gives kind of three general areas or three times or justifications, I guess you could say. So if the information received by the appointing authority is serious, that termination is likely, that may be a time that they decide to put someone out on leave. If the employee is going to compromise any safety and security at the work site, or if the employee's presence may impede the investigation.
Okay, and directing your attention to the first factor, again, the alleged work rule infraction is so serious that termination of the or of employment is likely. What does that mean?
So there are certain behaviors that if the alleged, that the Department of Corrections, if proven to be true, we would always request a termination of employment. So that's what that would mean. So if the information that the appointing authority received may fall under one of those things, they may place someone out while they're conducting the investigation. And like I said, if proven true, we would request a termination of their employment.
Okay, and you said if proven true, so I just want to follow up on that. Does an appointing authority have to have all the evidence necessary to terminate a staff member before placing the staff member on administrative leave under that first factor?
No.
Okay. So what is the purpose of placing the employee out on leave under the first factor?
Again, the information they received, and it's most likely they're going to be terminated if it's proven to be true, would be the purpose of it, so that they're not continuously working in the workplace. I'm assuming that's.
So
Again,
they're not required to collect evidence first before placing them on administrative leave under that factor. Is that accurate?
yes, that's accurate.
Okay. Judge, I now would like to move to Respondents Exhibit number 5, please. And I believe this one has already been admitted, but again, you might want to double check.
Yes, we marked that at the beginning of the day yesterday. Good. Okay, response exhibit 5 is on the screen, and we're at page 72, going to the first page of that employee discipline document to page 73. Go ahead.
Okay, Ms. Brown, do you recognize this document?
Yes, I do.
And what do you recognize it to be?
This is the DOC executive directive that outlines our discipline process.
Okay, and you're familiar with this document?
Yes, I am.
And what's the approval, the date of approval on, let me back up. What's the new effective date of this document?
This document was effective January 4th, 2019.
And who signed the document?
It was Secretary Carr.
Kevin Carr?
Yes.
Okay. Judge, if you could go down to page 76 of this document for me, please. I'm looking at section 6.
All right, we're on page 76. You said section 6 there.
Yes, please.
Go ahead.
Okay, well, let me just back up. So is this a statewide document or a statewide policy?
This is a department-wide policy, so it's not the statewide policy.
Right, so and by department, you mean Department of Corrections,
Yes.
correct? Okay. So directing your attention to section 6, can you explain what that pertains to or what that addresses, please?
So this also addresses the administrative leave with pay and the appropriate times someone can be placed on administrative leave with pay.
And does this largely mirror the administrative leave pay in the statewide policy we just addressed?
Yes, it does.
Okay, it has the same factors?
Correct.
Okay. And it's the authority is also with the, well, let me ask you, under this policy, who has the authority to place somebody out on administrative leave?
It's the appointing authority.
Okay. And Judge, if you could go down to the next page, I'm looking for section 7, please. Okay. Ms. Brown, directing your attention to section 7, can you just address what that pertains to?
The being able to give a work directive and letter of expectation, is that the section you're talking about?
Yeah, section 7, I'm sorry.
Okay. So this just indicates a time, well, indicates that we can give, a supervisor can provide a work directive, job instruction, or issue a letter of expectation regarding an expectation that they want to see moving forward. And it's saying that neither one of those things are considered formal discipline.
Okay. So focusing now on the section just below that, section 8, what does that pertain to?
So that helps provide some guidance on determining an appropriate level of discipline based on the misconduct that has been proven and investigated.
Okay.
Now that you've scrolled down, it also kind of gives what our attendance policy is here with the Department of Corrections. So that's what Part B goes into as well.
Okay. And Judge, if you could go down to the next page, I'm looking for, in the same section 8, I'm looking for letter C. Perfect. Ms. Brown, directing your attention to section C here, what does that pertain to?
So this is the progression schedule that we need to follow with regards to when someone violates a work rule. And this would be the same actually statewide. We all have the same progression schedule.
And how many levels are there in the progression?
There are 4.
Can you just read those off for me, please?
Sure. First, the first violation is a 1-day suspension without pay. The second is a 3-day suspension without pay. The third is a 5-day suspension without pay. And the fourth is discharge.
And you had testified previously that serious acts of misconduct do not need to follow this progression, correct?
Correct.
But they can follow the progression, is that correct?
Yes. Yes.
Okay. And Judge, on the, I believe it's the next page, I'm looking in this same section, I'm looking for letter G.
All right, we were just on page 78 of Response Exhibit 3, and now you said you wanted page, okay. We're now on page 79, Respondent Exhibit 3, Section G, Serious Acts of Misconduct. Go ahead.
Ms. Brown, focusing your attention to section G, what does that section address?
So this section lists the 9 serious acts of misconduct that are the same statewide, and it states that we may impose a more severe level of discipline if an employee also has a serious act of misconduct listed with work rule violations.
Okay, and you said that these mirror the serious acts of misconduct in the statewide policy. Did I hear you correctly?
Yes.
Okay. And Judge, if you could just go to the top of page 80. Right there, please. So, Ms. Brown, do you see the paragraph there under item number 9?
Yes.
What does that pertain to?
So in addition to the 9 serious acts of misconduct that are statewide, the DOC was also able to get approval to have 5 additional ones to be added that are specific to the DOC. So that's what these 5 list, because they're specific to our agency and not necessarily to all state agencies.
Okay. And Judge, if you could now go to page 81, I'm looking for section 10.